Hey guys, it's George Saldana with Texas Team 2503, and today I want to go over House Bill 3181. There's some advocates that are posting House Bill 3181 as a big win for parents in this movement. And so I think a lot of people are just taking it at face value and not actually reading the bill. So let's go over House Bill 3181 and let's see if this bill that will become law is beneficial to this community. Okay, so House Bill 3181 was brought by Texas State Representative Harold Dutton. It was sponsored in the Senate by Senator Angela Paxton. When you walk the halls of Austin and you meet with legislators and you talk to other politicians, lobbyists, you seem to start connecting the dots. And anytime I see Texas State Representative Harold Dutton's name on a bill, I can already assume that the Texas Family Law Foundation, which lobbies for attorneys and their law firms, are going to support his bill. He's an old school gangster representative. He knows what he's doing, he knows how to politic. See, the Texas Family Law Foundation, while that foundation sounds great on the outside, they really only lobby for attorneys, family law attorneys' interest and their law firms. And for the last several legislative sessions, the name Amy and Steve Bresnan always come up. And anytime pro se litigant parents are in there testifying, they hate it. They hate pro se litigant parents that go to Austin to testify because they don't like us competing with them. And they get paid almost $1 million to lobby every year for the Texas Family Law Foundation. And they pretty much go against us all the time. So when this bill came out and they were supporting it, it kind of threw up some red flags. Now, we've seen the Texas Family Law Foundation give Texas Representative Harold Dutton awards, campaign contributions. So I believe over the years that I've seen this relationship, I believe the Family Law Foundation is in Texas State Representative Harold Dutton's pocket. So if you look at the witnesses, you can go on Texas Legislature online. You can look up the fiscal notes. You can look up the witnesses, the texts, how they enrolled the bill and how it was engrossed and where it's at, and it's headed to the governor's office. You can see all of that on the state's website. So if y'all feel like checking this information, feel free. Texas Legislature online, enter House Bill 3181, and it will pull up. So let me read the highlights on this flyer that is circulating social media. Big win for Texas parents. House Bill 3181 passes the Senate. It requires makeup time for any denied visitation. Great. Doubles the time back if the other parent has been found in contempt before. Great. Sounds really good. Allows custody modifications for repeat violations. Sounds great. Stops judges from waiving attorney fees when a parent has repeatedly interfered. Sounds great. Now let's dive into it. So, House Bill 3181, relating to the enforcement of a court order for possession of or access to a child and related other modifications. That's what it's relating to. Section 1, Subchapter B of Chapter 156 of the Texas Family Code is amended by adding Section 156.107 to read as follows. So they're going to add a section into the Family Code, and this is what they're adding. A finding by the court that a conservator is in contempt of court for the denial of court-ordered possession of or access to a child has previously been found in contempt of court at least 3 times for failure to comply with the terms of an order providing for possession or access to the child constitutes a material and substantial change of circumstances sufficient to justify modification of an existing court order or portion of a decree that provides for the appointment of a conservator or that sets the terms and the conditions of the conservatorship for the purposes of or access to the child. That's what they're adding. Another portion they're fixing to amend is section 157.165. Except provided by subsection B, the court may place. And if you know anything about law, may is discretionary. So the judge can say yes or no, which is a very dangerous word in family court. It gives that judge that discretion. Except as provided by subsection B, the court may place the respondent on community supervision and suspend commitment if the court finds that the respondent is in contempt of court for failure or refusal to obey the court order rendered as provided in this title. The court may not place the respondent on community supervision and suspend commitment if the court finds the respondent is in contempt of court for failure or refusal to obey an order for possession and access to the child and has previously been found in contempt of court at least 3 times for failure or refusal to obey the order for possession and access. So we can't put you on community supervision. We can't suspend your community supervision if you've already been held in contempt and it's been found has previously been found in contempt of court at least 3 times. Well, I would hope you wouldn't put that parent back on community supervision if they've violated that court order 3 times. But that's the second portion that's being amended, 157.162. The court may not place the respondent on community supervision. So it's totally up to the judge whether they want to put them on supervision or not on community supervision, and has previously been found in contempt of court at least 3 times. You tell me what you think of that. Section 4, Family Code 157.168 is amending subsections A and A2 and adding subsections D to read as follows. Unless a party shows good cause why the order should not be rendered, a court shall, which creates an obligation. Shall means almost mandatory, but not mandatory. It creates an obligation. The court shall order additional periods of possession of or access to a child to compensate for the denial of court-ordered possession and access to the child. A2, the additional periods of possession of access, except as provided by subsection D, must be, which is mandatory, must be the same type and duration of possession of or access that was denied. So if it's a weekend, it's a weekend. If it's a summer, it's a summer. May include weekends, holidays, and summer possession of or access. Must occur on or before the second anniversary of the date the court finds the court order possession and access has been denied. This one must occur on or before the second anniversary of the date the court finds the court ordered possession and access was denied. Some of y'all know that sometimes these possession and access contempt orders last over a few years. But that's already in the bill. I kind of found that when we were looking over this. This is what was added to D. If the court finds that the person denying possession and access has previously been found in contempt of court at least, how many times? 3. For the denial of court-ordered possession and access with respect to the child who is in the subject of the proceeding, the additional periods of possession of or access to the child ordered by the court order of this section must be, in total, twice the duration of the periods of possession and access that were denied. So, if your ex has been found in contempt 3 times for the denial of court-ordered possession and access, and they were all on weekends, you're going to get that time doubled back. If the court finds that the person denying access has previously been found in contempt at least 3 times, the denial of the court-ordered possession and access with respect to the child who is the subject of the proceeding, the additional periods of possession of or access to the child ordered by the court under this section must be, in total, twice the duration of the periods of possession and access that were denied. Weekend for weekend, summer for summer. So at what point are we buying our possession and access? The issues I have with this bill, House Bill 3181, a finding by the court that a conservator is in contempt of court for the denial of the court ordered possession of access to the child has previously been found in contempt of court at least 3 times. This is another 3 strikes bill. Some of y'all have been watching me. I made a video about the last 3 strike bill for interference with child custody. It didn't pass and make it to the governor's desk, but this one did. And this 3 strike bill says that the court has to have a finding at least 3 times for failure to comply. If you're in the family court arena and you're in family court and you've ever tried to enforce your court order through contempt actions, you need to ask yourself, how much is a contempt action? How many violations do you need to bring a contempt action? How long of a loss of possession and access time do you need to bring a contempt action? Sure, it could be once, it could be 3, it could be 5, but let's just go on the premises of 3 violations to bring a contempt action. So you have first, third, and fifth Fridays. So let's just say that's a month, 1 whole month of being denied possession and access. You have to go and file for a contempt action. That contempt action is going to cost you 25 to 5,000 bucks, maybe 6,500, depending on the type of lawyer you get. I know my contempt action. I've only been able to get one, and I paid $3,500, and it was hell to get a finding of contempt. So you're looking at 3 contempt actions at 25 to 6,000, 7,500 on a high scale attorney. Now, how is this beneficial for you as a parent? That now at least 3 times a finding by a court that the conservator is in contempt of court at least 3 times for failure to comply with the terms of an order providing for possession and access to the child. Now it constitutes a material and substantial change. When testifying, Senator Birdwell asked if that threshold was too high. 3 contempt actions. Should it be 2 contempt actions? And they were inquiring about possibly even changing it. Judge Carl Hayes from Hayes County, he testified for himself, but he is part of the Family Law Foundation. He drafted this, and he also said that he believed the threshold was a little high and that he wrote it as 2. So somewhere in there, they moved it to 3. And the Family Law Foundation loves this. And I understand why they love this. You're going to be putting more money on these lawyers' plates by trying to chase down a contempt action. If some of y'all know the judges aren't enforcing the law. They kind of just do what they want. It could really be impossible for some parents to chase down 3 contempt actions and paying that much. So when it comes back to double time, are you paying for your double time? You have to get 3 contempt actions. You're going to get double time. But at what point are you paying to be a parent to your child? We have other mechanisms of enforcement. We have interference with child custody. We have House Bill 969, which hasn't done anything for a 3 strikes violation where you can get a $500 civil ticket. People were pushing that last session. It passed. No county in the state has issued a ticket. So by adding this to the Texas Family Code, now it's saying that you have to have that parent, the respondent parent, in contempt 3 times before there is a circumstance sufficient to justify a modification. And then you're going to go into modification, and then you're going to go into mediation. No wonder the Family Law Foundation was all over this. It's making money for attorneys because you have to have 3 contempt findings. Like interference with child custody, the 3-strike bill that didn't make it to law, it was the same thing. They want 3 convictions for interference with child custody before they make it a felony. These 3 strike bills are horrible, and we need to start calling them out. People, please start reading these bills word for word. Word for word. So while this is going to help enrich attorneys on the family law side, what is it going to do for parents? Do you have $10,000 to bring 3 contempt actions? Is the judge going to give you 3 contempt actions? Do the judges even follow the law? Is there even oversight on these judges not following the law? So basically, you're a cat chasing a legal fiction, a cat chasing its tail. I just went over it. Tell me what you think in the comments below. Thanks for watching. I will be coming up with a legislative video that talks about the overall experience I had this legislative session, the ups, the downs, and the turnarounds. We'll go over it. So please come back to watch that video. But I really am curious to know what you really think about this 3-strike House Bill 3181. Again, it's been passed. We're going to have to fix it, or we're going to have to constitutionally challenge it to find some form of relief. I think it's ridiculous that you have to find 3 findings of contempt before you can double your time, before you can actually really hold that parent accountable. I think the threshold is a little high. And I think Senator Birdwell and I talked about that in our testimony. With that being said, guys, thanks for watching. Y'all have any other comments, observations y'all want to make, please post them in the comments below and keep sharing these videos. It helps other parents that are going through these types of issues in family law start engaging, start understanding what's going on in the real world. Thanks for watching, and we'll catch you later.